Welcome back, everyone, to our next video segment. This time we're talking about preventing and responding to third-party harassment. I know that might not be a term you've heard before, but it's a very important term in the hospitality industry. And once we're finished, you're going to understand why. Today, we've brought back, always by popular demand, two top lawyers around the country in the labor and employment field. Andria Ryan, a partner in the law firm of Phillips, and one of her partners, Alden Parker at Phillips. The two of them co-chair the hospitality practice for the firm. Ladies and gentlemen, if you ever need insight, guidance, legal advice on labor and employment issues, you want to reach out to the Phillips law firm. And I would suggest you start with one of these two people. Andria is in the Atlanta office. Alden resides in California and oversees everything California. I refer to him as the California guru. If you guys haven't figured this out yet, there's 49 states in California. So, and he can distinguish for you. And that's an important thing for a lawyer to be able to do today. So I'm going to turn it over to them, and we're going to have a presentation on third-party harassment. Please welcome Andria and Alden.
Thank you, Stephen. We appreciate the opportunity. And here we are talking about harassment. In fact, as you see here, we say, why are we still talking about harassment, right? We've had some tumultuous years on this issue. We've gone through the Me Too movement. We've got this Harvey Weinstein effect, and they're still alive and well. For some reason, we in our workplaces, we remain challenged by harassment concerns. There are, especially in the hospitality industry, there tends to be a blurring or a crossing of professional boundaries. People work long hours together in close quarters. With staffing shortages as we're seeing them now, there's lots of folks who are spending a lot of time with their coworkers. So this is an issue that is not going away. In fact, the EEOC tells us that the harassment charges have not decreased in any significant way over the past 10 to 15 years. So we want to keep this issue on your radar, especially in challenging states like California, which have very specific requirements about sexual harassment policies and training. And many states are following in their footsteps. Alden, wouldn't you say?
I think they are. I mean, I think it is accurate to describe, the United States as 49 states and California. If you were to travel to California and it was all based on the legal system and the legal laws that are, anti-employer, you would have to go through some sort of international passport check to get into California because it's so problematic and different. But you're right. California has specific laws regarding even third-party harassment. It is part of our Fair Employment Housing Act that employers have a duty to protect against third-party harassment.
Let's talk a little bit about what we're doing in an industry, what employers are doing, and why we seem to have taken our eye off the ball here. I mean, we make a note here, we're focusing on COVID and vaccines, safety issues, huge staffing challenges. But that's fairly new to the industry. I would say that we are, other than the required training in states like California, I think New York is moving in that direction, it's not an area we focus on in terms of training, and we should. So we're either doing poor training or very little training of both our managers and our employees. California requires employee training. Most other states don't. But I've had many clients over the years say, why would I train my employees about harassment? They'll just file a bunch of harassment claims. And that's not been my experience. In fact, I think your employees appreciate you being frank with them about how to deal with either their coworkers, their managers, or, as we'll get to shortly, third parties, guests, customers, who may say and do things that are inappropriate. I think they generally appreciate that you're frank with them about what your expectations are in terms of their behavior and what they should expect, what they should do to respond and to complain about inappropriate behavior directed at them.
Well, and Andrea, and I think that's a real good point. You know, it also should be stated, while sometimes training feels like you're giving employees a roadmap on how to get sued, you know, there are federal defenses that require things like a policy, an effective policy gets demonstrated, an effective complaint process, an effective training process in order to take advantage of some defenses relating to an employee's failure to complain about harassment, whether that's in the employment context or a third-party harassment claim, even in a state that doesn't necessarily have a training requirement. And so I think it certainly should be part of the regimen about going ahead and onboarding employees, and you'll have some more flexibility in those states that don't have the requirement. But with all these new employees, some of which may never have even worked in hospitality before, never even come across third-party harassment claims that our industry might have, I think it's all the more important to have that process in place.
So make it part of your system, make it part of your orientation program. Let's talk for a minute about what makes harassment unlawful. Harassing conduct has to be based on a protected category. And we've talked over the years, people complain about coworkers who aren't nice and people that are bully them. And that's bad behavior. And it's certainly things you want to deal with from an employee relations standpoint. But from the legal side, we're talking about conduct, harassing conduct, inappropriate conduct that's based upon a protected category. The focus tends to be on sexual harassment. It's certainly the most commonly filed claim of harassment. But don't take your eye off the ball here. Other protected categories include religion and disability and sexual orientation and gender identity and any other legally protected category. So not only do I want you to focus your training on that as well as your policy. Your policy needs to be broad enough that goes outside of sexual harassment. Despite that, again, sexual harassment is clearly the most commonly filed complaint.
Yep.
But we're seeing some increase here as well.
Yeah, I think we are. I mean, certainly some states will have a real long laundry list of protected, categories that can both form the basis of discrimination and harassment. I would still say, in my experience, as far as harassment claims, sexual harassment still seems to be the most prevalent, especially in the hospitality industry.
Right. Well, speaking of that, this is a survey that I came across a couple of years ago. The Huffington Post surveyed about 2,200 female employees in the hospitality industry. 1 in 3 said they had experienced sexual harassment at work. And interestingly, 16% of the women who said they'd not been sexually harassed said that they had, however, experienced sexually explicit behavior or remarks. And 42% of women in the food and service and hospitality industry reported sex harassment. It was the highest of any field. And in fact, the EEOC statistics bear that out as well, that hospitality, food service, restaurants have the highest number of harassment complaints of any industry.
Yeah.
So it's something the industry, we need to take seriously as an industry. We need to focus on it.
Andrea, I find the challenge in talking with hospitality employers and then dealing with the trainings with hospitality employees is to make sure that everybody knows that while the industry is about guest service, it's about making sure a guest feels welcome, making sure that they have an enjoyable experience with us. Many times that includes, imbibing in alcoholic beverages. That there still is a line between that and harassing behavior that's inappropriate in the workplace, and that we as hospitality employers know that line, we recognize it, we want to respond to it if employees come to us with that information. And then we just aren't going to let guests do whatever they want, but we understand that there is a certain segment of stuff that is about guest service and experience, and then there is a line that we won't let people cross.
That's right. It is a recognized problem in the industry. And as we've said, it's a bit unique to your industry. Maybe retail has some claims like this as well. But imagine a manufacturing facility. They generally don't have to worry about third parties on their site harassing their employees. They need to worry about other employees. They need to worry about supervisors and managers. but they don't generally have to worry about third parties that they have limited control over. And so we want to think about third-party harassment. We're generally talking about guests and customers and visitors and vendors or contractors who come, other business associates, people that you're commonly doing business with. And as we point out here, what do you do if you can't discipline them like you can? You can't terminate them. You can't issue a final warning. You can't do additional training like you would with a manager or supervisor that's not acting appropriately. So, you've got to start thinking about what level of action you're going to take if you've got a customer or a guest with a severe or a persistent problem. Are you prepared to remove them from your premises? And how would you do that? And who would you like to do that? And who should be responsible for making that decision? But we need to think about how to protect our employees. It's time to be proactive about this issue. So I would say, as you see here, some important steps. Make sure third-party harassment is specifically included in your policy. I would write it, I think Alden, you would agree, we would write, this policy specifically includes guests and customers and people you come into contact with that are not employees. Please report it. The way you would harassment.
I think you're exactly right. I mean, if you're faced with a third-party harassment claim, whether it's under California's FEHA law or some other state rule that goes ahead and prohibits or puts on an employer a requirement to protect against third-party harassment. But if it's not in your policy, you're immediately going to get dinged up by opposing counsel. And that plaintiff's counsel is going to say, you wrote this policy, you included the different things you're protecting against, and you didn't include third-party harassment by guests.
And then train your employees, train your managers. We've talked a little bit about this, and keep a record of that training. Even if you're outside of California and you're not doing it by legal fiat, it's valuable training. What I want you to pay attention to for a moment is this third bullet, and it's near and dear to my heart because I do a lot. Alden and I, we work almost exclusively in the hospitality industry, and I would urge you to sit back and think about who your most vulnerable employees are to harassment. I asked this of a group I was training one day. I just threw it out there. I said, who do you think your most vulnerable employees are to guest harassment? And I got a few people say the front desk. And I said, well, not that kind of harassment, not the kind of harassment, I'm not getting what I want harassment. I mean, sexual harassment. And then we started to peel that back and we said, well, bartenders and servers and in-room dining and housekeepers. And, we started to peel this back. Our landscape employee, maybe not so much, but what about a golf cart attendant? What about somebody who's driving, young people or hostess? So identify those groups. Where are you hiring particularly young people? Are your hostesses, for example, all 16, 17, 18-year-old folks? Absolutely no harm, and I think it would benefit you to pay some extra attention to who's talking to them, what kind of interactions are they having with your guests? Your chefs and your cooks are we've got other harassment issues that maybe we have to deal with those folks, but they're not generally interacting with your guests. But your young, vulnerable employees are.
Yeah.
And as I said here, as we said here in the next bullet, give them a script. Tell them what you want to say. It's interesting because folks that work in spas, massage therapists and other estheticians, they're told generally there's really good training about if a guest says or does something that makes you uncomfortable, say the following things, step out of the room and get a manager. But we don't tend to take that training to these other vulnerable employees. And I think it's important that we do that.
Yeah. Andrea, depending on the size of your organization, I've seen people go ahead and actually conduct separate trainings to the vulnerable population, those that we've identified have the most guest contact that may result in harassment. And they actually spend a little more time on third-party harassment than maybe even other group, and they run them separately.
Yeah. I think giving your employees the tools to respond appropriately and professionally, and then after they respond to the guest, they should be reporting to a manager who should be, all eyes and ears open to the concerns that they're bringing forth. I mean, here we urge you, take affirmative steps to deal with third-party harassment and keeping your employees safe. Don't blame your employee for coming forward. So many of them are really unprepared to deal with these very awkward and uncomfortable situations. Don't punish your employee. Don't give them a different shift. Don't take them off the schedule. You know, they shouldn't, you know, you got a big group of rowdy, had too much to drink businessmen. They shouldn't be removed from the table because they're misbehaving and miss the potential opportunity for that kind of income. That's not how we need to solve that. I mean, we need to protect our employee, but we need to make sure we're not punishing the employee for a guest's bad behavior. And then, you know, we got to be in a position to remove guests who won't comply. You know, which manager is going to issue them a directive to address their behavior, and then who's going to make the decision that it's time to remove a guest or a customer from the premises. I think, Alden, what we mentioned here in these last two slides is what we often mention with regard to any harassment situation. And that is, these are important, harassment situations are important to circle back with the employee, assure them that the matter is being handled, give them some information about what we've done to handle that. You know, radio silence is not a good idea here.
Right. And I think that the challenging part on these last two bullet points in our industry that moves at such a rapid pace and has so many contacts with third parties is that these need to be documented in the same way that we would be documenting an employee interaction that results in a complaint or some sort of knowledge of inappropriate behavior. We've got to be documenting that follow-up. We've got to be documenting that the complaint came in. It's very hard, and it's just going to be lost in the ether about what happened and when it happened and who it happened to when you're dealing with something in litigation, in my world, where the litigation is coming up years after the alleged instance of inappropriate behavior. And so the documentation is just so key in that instance that it can't be emphasized enough.
And then follow up with the employee. Go back, do some touch points, and I mean figuratively, and that is, you know, how's it going? Is that guest continuing to bother you? Is there anything's been said to you that makes you uncomfortable? Do you feel empowered to deal with this situation? So follow up for, you know, periodically for a couple of months, I would say.
Yeah. One of the interesting things, Andrea, that I've experienced before is that the manager should be looking to see if the guest primarily that's interacting in an inappropriate way is a transitory guest or are they a repeat guest? Because there may be a different approach that has to be provided depending on what type of guest that's there. We're guarding against the repeat guest that does show up in a regular pattern to the establishment. There may be one level of treatment you have to do to protect the employee from that person again, as opposed to a transitory guest that may never show up to the establishment again.
Right. Good point. Good point.
Guys, thank you. I've got a thought that I just like to share, and that is, I think it's important that for the people listening, never ask your employees to manage these types of situations themselves. Right? Andrea mentioned to you creating kind of a script for them, and that's one thing. But if that doesn't solve it, then you've got to take the affirmative steps to keep them out of harm's way. And whether it's a guest, I've heard about this also a lot, as Andrea mentioned, from the vendor side. And you need to be ready to pick up the phone with that vendor and say, hey, this person cannot come back to our space. If they're a delivery person, whoever they are, they're not welcome back, right? And so that's a long-winded way of saying I have a question. Alden, in California, this type of training, I think, can you just specifically talk a little bit more about the training that's required out there?
Sure.
If you know how often it has to happen, things like that.
Yeah, so we have a training requirement for managers that is every 2 years, 2 hours. There are required topics that are part of that. One of them being third-party sexual harassment, along with a bunch of other areas that could come up. And then employees are looking to be trained at least 1 hour of time if they're a non-managerial employee. Their training requirements have some flexibility about online training versus in-person, but they do have to be interactive and meet some level of interaction. And that can be very, very challenging for everybody to go ahead and comply with over time, especially where we are hiring, again, people that may never have worked in hospitality again because of labor shortages. They may never have had experiences that a lot of seasoned employees in the hospitality industry have had and are better equipped to deal with on an individual level. And so they'll be looking for that guidance about what they are supposed to do when a guest acts a certain way. And the expectation out here is they're going to be trained on it. They're going to know the policy and they're going to know what to do.
That's very helpful. Thanks. And I do want to emphasize, and I assume you agree, that the mandated training is the minimum amount of training you need to do. I think, Alden, that they should be reinforcing the concepts behind the training on a regular basis. Do you agree?
I think that's wise. Again, the more you can do, if you have a work environment that is, really meant to have a lot of personal guest experiences, where you have probably a higher level of potential inappropriate action with guests, late night establishments, alcohol, the presence of that, lowered inhibitions, that type of thing. You're looking at a situation where I think you have to scale up from the minimum in order to meet an expectation that later on, through the lens of litigation, your place is going to be judged against.
Yeah, very helpful. Andria, my feeling is given kind of the state of the country, the divisiveness and everything that's going on, that we're also going, as you guys mentioned, we're going to see this type of harassment, not just in the sex-based area, but in the religious base, in the national origin basis. I know the majority of claims are sexually oriented, but are you seeing some claims in these other protected areas as well?
Yeah, we do. We tend to see some sort of blips. After 9/11, we saw a real increase in claims of harassment based upon national origin or religion, and we see some claims based upon age. It's interesting, Stephen. I'm glad you mentioned it. We sort of all, or at least we're getting on our radar, right? Sex harassment is wrong. We don't say certain things. There's certain things that are racially based that we know we don't say at work, but other things fall off, right? They're not high on your radar. So age-related comments based upon somebody's hearing impairment or disability or Alzheimer's jokes, or those kinds of things are just don't feel as politically incorrect as the others. And so it's important to emphasize, a respectful work environment, and specifically, tailor your policies and your training to things other than sex.
Yeah, listen, guys, this is great guidance. Thank you both very much. Ladies and gentlemen, I do want to mention that if you haven't been to the Fisher Phillips website, you will find a wealth of information and resources to assist you in trying to make some choices at your property. Remember, we can't give you legal advice. We're here to provide you education, but it's always best to contact local counsel because the law changes from location to location. Andria, Alden, as always, thank you both very much for this very insightful and cogent presentation. We look forward to the next one.
Thanks, Stephen.
Thanks for having us.